So we've identified 7 major dangers that the second and third generation face. These are issues that we see all the time as we visit not only with clients such as yourselves, but the other family members through the trust administration and other avenues. Very first danger. Anytime we have a client who has minor children under the age of 18, the very first question is, have you thought about who's going to be the guardian of your children if you and your spouse pass away? If you do not nominate your guardian for your children with your last will, testament, or similar document, it is completely up to the court to decide who is the best fit to be guardian of those children. We may be talking about grandchildren, great-grandchildren eventually. It's up to the parents of those children to make that determination. And when doing that, those parents need to consider real-world issues, not just who lives the closest by, who comes and visits the kids the most, et cetera, et cetera. You need to think about who can handle decisions about where they're going to live, where they're going to go to school, who can handle the assets or the funds that they may be required to do. Obviously, in a bad situation, if we do not nominate a guardian, if your children, grandchildren do not nominate a guardian for their minor children, you could end up with a contested guardianship at the courthouse. You could have multiple parties wanting to serve as guardian. Eventually, there's even situations where the state could step in and take custody of the children until a guardian was appointed. So you can see this can unravel really quickly, not in the best interest of the children, obviously. Number 2 danger is allowing the children access to their entire inheritance too early, which is exactly what happened to this young lady. Okay? She went on a spending spree with her friends, and that's probably her new car as well. We typically, in our experience, it's not a good idea for 18-year-olds to get a large sum of money just dropped in their lap without any restrictions. Absent a trust that restricts those assets and the distribution of those assets, then if the estate goes through probate, then it goes through maybe a guardianship if they're minor children. The day that they turn 18, they get every dollar of their inheritance. That's strictly statutory law in Oklahoma. That's really cannot be changed for the most part. And of course, most clients share with us that their biggest concern is that their children are going to be taken advantage of financially, creditors, and other outsiders. Allowing the children to get their entire inheritance at age 18 only makes that worse. Danger number 3 is not protecting their grandchildren, from predators and creditors. Beneficiaries that are young, obviously, are more prone to persuasion. But these predators and creditors, sometimes they could be spouses. In our example, if a grandchild receives their entire inheritance at age 18, turns around and gets married a year or 2 later, and then gets divorced, is their spouse going to get a portion? How much of that estate? Could be 50% of their estate if it was commingled into marital property. Then they took those funds and bought a house and put it in both names. Obviously, young children are very higher prone to have creditor issues, whether it be credit cards, automobile accidents, medical bills, things like that. If we have children with special needs, that's something that we have to take care of in the trust, because if they're receiving governmental benefits pursuant to their special needs, they would become disqualified if they were to inherit assets through a probate or a guardianship. So we want to tie those up, hopefully, keep those away from the state, keep them for the benefit of the grandchildren in that situation. Now, this lady just found out that her family's wealth went outside of the family, okay? How would you feel if your hard-earned wealth, instead of staying with your children, grandchildren, went to some third party who you've never met, never will be? That's a danger number 4. How does this happen? Take the example of if your grandchildren were to inherit an estate in their name individually, because there's no estate plan in place. That grandchild gets married, those assets become marital property, then either the grandchild gets divorced or they pass away, Anywhere from 50% to the entire estate could pass to their surviving spouse or their ex-spouse. Then that spouse gets remarried, has children of their own, and it further gets spread remote from the family tree. So as you can see, a lot of situations where unintended beneficiaries can receive property from the family. Beneficiary designation forms are especially important. We see a lot of situations where young people will set up a retirement plan, they'll take out life insurance, maybe when they first get out of college or when they first get married before they have children. And on the beneficiary designation form, they may name their spouse as the primary beneficiary, and they may name their parent or some other relative as the contingent beneficiary. And then a few years later, they have children of their own. And if they don't go back and change that beneficiary designation form, and something happens to them, who's going to receive the funds? Whoever they put on the beneficiary designation form. So if that doesn't get updated, their children could be completely cut out of the funds. So that's another trap for the unwary. Next, we're going to talk about family members fighting with each other over money. This exists in every estate. We've talked to each of you in detail in developing your estate to try to avoid this exact situation. However, anytime you have a guardianship or a probate due to a lack of a legacy wealth trust where all the essential elements have been put in place, you leave yourself exposed to family arguments. Who's going to be guardian of the children? Who's going to be in charge of the assets? Who's going to be in charge of the probate? If it does go through the court process in a guardianship, if we have minor children, how do you think the minor children are going to feel towards the guardian, the person who otherwise is the guard at the gate, keeping them away from their money until they're old enough to do it themselves? A lot of potential conflict there, unnecessarily, because those decisions have not already been made. You're just leaving those decisions up to the court in that situation. Number 6. Many people are surprised to learn that when the day that their children turn 18, they no longer have access to their children's medical records, or really any decision making on behalf of their children. So if there's a child or grandchild that's about to be 18 or just turned 18, their parents have no access to their medical records, can't make medical decisions for them. Even though they're probably still supporting them financially, they may still even live in mom and dad's house, but they have no access. So if these kids go off to college, it creates a real problem. Finally, this last danger we're going to talk about is the financial inexperience and lack of long-term planning. This is especially difficult for young couples, young families. They have so much on their plate. The last thing they want to start thinking about is planning for their future when they're in their 60s and 70s and so forth, and sacrificing today to take advantage and preparing for the future. And we see that as such a critical mistake because it's so important to start early due to a lifetime of earnings. We want to eventually take their assets, any inherited assets, provide an income stream for the children, for the grandchildren, give them some level of comfort for the rest of their lives. Life insurance is a big part of that. Anytime you have young couples with children, you have to think about what happens if one of the parents were to pass away. Even if you have a 2-income family that's been cut in half, nowadays that could be a financial strain that needs to be hopefully planned for accordingly. Okay. So most of the people in this room, we've already been through this analysis with you. You know this, but do your children, do your grandchildren know this? Okay. Knowledge isn't enough. You have to have a plan of action.